And the National Prosecuting Authority's appeal against a High Court ruling relating to the spy tape saga tomorrow. The appeal follows a ruling in April last year in which a judge ordered a review of a 2009 decision by the NPA to set aside hundreds of charges against the president, describing the original ruling as irrational. This effectively reinstated the 783 fraud, racketeering and corruption charges withdrawn by former NPA head Mokotedi, paving the way for Zuma to become president in 2009. Both the president and the NPA then approached the Supreme Court of Appeal after the High Court refused the request to appeal.
It's the 12th of January 2009, a few months before the 4th Democratic General Elections. The Supreme Court sent jitters through the political landscape. The NPA successfully petitioned the court to overturn a 2008 High Court ruling which essentially barred it from prosecuting Jacob Zuma.
A prosecution is not wrongful merely because it is brought for an improper purpose.
Fast forward 8 years later, in the same court, the NPA is now in President Jacob Zuma's corner, this time challenging a High Court ruling that it was irrational to drop the charges against President Zuma in 2009.
Mr. Zuma should face the charges as outlined in the indictment.
The court held that the acting NPA head, Mokotedi, acted impulsively after listening to the recorded conversations between his predecessor, Bulelani Ngcuka, and former Scorpions boss, Leonard McCarthy. The president contends that the abuse of process forced Mshe to use his legal powers and drop the prosecution. In the court papers, the president's counsel raises a quagmire. They say the High Court essentially forces the NPA to prosecute President Jacob Zuma, even though the NPA has indicated that such a prosecution would be unfair to the accused. It says that should the NPA implement the court ruling, it will give rise to an application for a permanent stay, and the NPA would then have to oppose it. The DA maintains Zuma must have his day in court.
We are in it for the principle that nobody in South Africa, whether that person is the president of South Africa or the person living on the street, is above the law, and that the law applies equally to everyone.
The matter has been set down for Thursday and Friday. Aldrin Sampear, SABC News.
Aldrin Sampear has been following this story for quite some time now, and he now joins us via Skype from Bloemfontein. Aldrin, thank you so much for joining us. Now, take us back to where it all started. Why are we going to court today? Why are we seeing the both sides, that is the NPA and President Jacob Zuma, appealing the decision that was made last year?
Well, it's such a long case that started many years ago, dating back to when President Jacob Zuma was still the deputy president of the ANC. And remember that after the Judge Squire judgment handed down against Sabir Sheikh, who was then the financial advisor of then deputy president of the ANC, Jacob Zuma, that judgment which found that there are these allegations of corruption against President Jacob Zuma, and there's merits to these allegations that have been made. And you remember that Bulelani Ngcuka at the time, who was the person who was the NDPP at the time, decided not to prosecute President Jacob Zuma with Sabir Sheikh. However, though, after the Judge Squire judgment, which also led former President Thabo Mbeki to fire President Jacob Zuma, and then a few years later, the NDPP at the time then decided to reinstate the charges on charge President Jacob Zuma, who was then contesting back in 2007 to become the president of the ANC. Quite interestingly, though, at the time, you remember that it was Thabo Mbeki was also contesting a third term in the ANC at the Polokwane conference. Now, what has happened since then is that after that decision was taken to prosecute President Jacob Zuma, the telephone conversation between Bulelani Ngcuka, who was then not an NDPP, who had left, I think, back in 2004 already at the time, had this conversation with Leonard McCarthy, McCarthy, who was the incumbent of the Scorpions, and Bulelani Ngcuka had no business whatsoever discussing the timing and the prosecution of President Jacob Zuma. And they discussed when President Jacob Zuma should be prosecuted, whether he should be prosecuted before the Polokwane conference or after the Polokwane conference. And you remember that after the Polokwane conference, they then decided to serve the indictment on President Jacob Zuma. That indictment was served. President Jacob Zuma argued that this court case is brought it's a political ploy, that this court case is being brought against him. And he went on to challenge the decision by the NPA to institute these charges against him. And then there's the Nicholson judgment. And the Nicholson judgment effectively said that there was political meddling in President Jacob Zuma's prosecution, who was then, of course, had been elected in 2007 as the president of the ANC, but not the president of the country yet. So this was now in 2008 that judgment came down. But then the NPA then decided to appeal that court case. That court case was then appealed successfully at the Supreme Court of Appeal, and in that insert that we've just played at the moment, we heard the judge there handing down the judgment where the NPA successfully appealed the case and essentially gave way for the NPA to continue its prosecution against President Jacob Zuma. Then a few weeks later, came these so-called, what we now call the spy tapes, and as indicated, it is a telephone conversation between Leonard McCarthy as well as Bulelani Ngcuka, the former NDPP. And President Jacob Zuma then argued that based on this conversation that was happening, there was an abuse of process as well as malice on this case and trying to prosecute President Jacob Zuma. And they managed to persuade Mkoterimshe, who was the acting head of the NPA at the time, and he then decided to drop the charges and not continue with the prosecution. Now, you remember this was on the 6th of April, just a couple of weeks before before the general elections were to take place. The DA has been fighting this matter ever since then, since 2009, even going so far as to the North Gauteng High Court to try and get transcripts of the conversations that the NPA had listened to. And that's where we found ourselves back now in the North Gauteng High Court, where this matter was then ventilated, and the North Gauteng High Court essentially arguing that President Jacob Zuma should face the charges, and the charges against the president should be reinstated. It was a matter that was welcomed by the DA. Of course, they were the applicants in that matter. However, though, President Jacob Zuma as well as the NPA decided to appeal, but that appeal was unsuccessful. The NPA then decided to go to the Constitutional Court to try and appeal the matter there directly at the Constitutional Court. But President Jacob Zuma had already come to the Supreme Court of Appeal to appeal this ruling from the High Court from last year. And then the Constitutional Court decided that actually we're going to send this matter back to you, rather go and deal with this matter at the Supreme Court of Appeal, because this matter is currently being ventilated there. And that's why we have the NPA also joining President Jacob Zuma in this case in trying to make their arguments. And just quickly let me just quickly point out some of the fundamentals of the arguments being stated in the heads of arguments, as well as the application being brought by the two. First of all, President Jacob Zuma's counsel is arguing that the matter is that his prosecution was tainted, and for that reason, the NPA has no business whatsoever continuing with this case. They also argue that Mkoterimshe's decision at the time was an accurate decision, considering the abuse of process, and President Jacob Zuma wouldn't have received a fair trial. On the other hand, NPA is arguing that if you look at the matter, and if you look at the judgment essentially does in the judgment saying that President Jacob Zuma should face the charges, is that the judgment clearly states or tries to take away the powers of the NPA. And the NPA is arguing on the basis of separation of powers that as the NDPP, it's the NDPP's decisions that the NDPP has the final say on whether matters should be prosecuted or not, and that's not a court decision.
Now, Aldrin, in terms of the Democratic Alliance and the NPA, how confident of a victory are the two sides in your observation so far?
Well, certainly all three sides in this matter are quite confident that the Supreme Court of Appeal will rule in their favor. I was speaking to the DA, the DA's James Self, and they said that they believe that the matter could go all the way up to the Constitutional Court, and that's a possibility. And even if you look into the documents of President Jacob Zuma, the Council of President Jacob Zuma, in this argument that they make, that essentially what the court is doing is that the court is asking the NPA to prosecute somebody that the NPA doesn't want to prosecute, somebody that the NPA itself had said that the prosecution against him would be unfair and it would not be in the interest of justice to prosecute him because that prosecution would be unfair on the accused. And the NPA is saying that President Jacob Zuma's counsel is arguing that should the NPA decide to implement this court ruling and prosecute President Jacob Zuma, that will give rise to a permanent stay. So essentially what that means then, that would mean that after the NPA decides and says, here's the indictment, President Jacob Zuma, we are going to prosecute you, President Jacob Zuma's counsel will go to court and argue in court that they want a permanent stay, they want a mistrial because this matter has been tainted, latest justice denied as well. And then on the other hand, you'll have the NPA that would also have to be in court and try to oppose this application. Now, can you just imagine a situation where the NPA is in court and arguing why it should prosecute President Jacob Zuma, where it has publicly stated before that there is no basis in prosecuting the president, considering they believe that this prosecution has been tainted and the processes have been abused by the former NPA boss Bulela Nguka, as well as the former Scorpions boss Leonard McCarthy.
Now, Aldrin, when the spy tape saga emerged a couple of years ago, the Scorpions, a former unit of the National Prosecuting Authority, were investigating President Zuma at the time for allegedly attempting to secure a bribe from Thompson, which has since been named Thales. Do we know if these companies are showing any kind of interest in the matter so that they can defend their own integrity?
Well, the difference with this case and where we are at this point is that we're not arguing the merits of the charges against President Jacob Zuma, the criminal case against President Jacob Zuma, but the focus is rather the process of prosecution, and that's the first hurdle that we need to get over before even there will be a criminal case. But in the original indictment, various companies are of course implicated. Thompson CSF is one of the companies, and of course the allegations being that President Jacob Zuma President Jacob Zuma received money from Shabir Sheikh, and the NPA was arguing at the time that that money was not just money, but it was bribes that were given to President Jacob Zuma, and that's the reason why they believe that President Jacob Zuma should face the charges and should face the 783 charges, and he should have his day in court and come clear on this matter. And it's probably only at the point where probably if we ever get at that point where the NPA decides to prosecute and go the criminal route and prosecute President Jacob Zuma, that we will hear from these various other companies. Some of these companies have obviously shut down at this point.
Now, the matter is scheduled for Thursday and Friday. Is this enough time for, within that 2 days, to get this decision resolved, or a decision from the courts or anything of the sort, in terms of where this matter is heading, and will it be a finality?
It's certainly an extraordinary situation, this one, because ordinarily what happens at the Supreme Court of Appeal is that when a matter is appealed in court, yet the Supreme Court of Appeal, only a day is set aside for such a matter. But quite importantly, it seems that the SCA takes this matter is that they set aside 2 days to ventilate the issues that are being canvassed by all three parties and interested parties in this case. So this matter quite important for the SCA as well as the NPA and all other two interested parties, because as I've indicated, ordinarily you only have a day that's being set aside. Whether the 2 days would be enough, I really don't know. But with this court case as well, which is another extraordinary thing, is that it will be argued in open court, which is normally something that the Supreme Court doesn't have, where you have the applicants to the Supreme Court who would have to argue on direct access to the court and also argue based on the application of Normally, direct access is being applied for, and then the Supreme Court of Appeal will decide without even having that matter being heard in court. And after that matter, and after deciding whether the matter after deciding whether this matter warrants direct access to the court, then only would there be open arguments being heard. But in this case, there will be open arguments being debated in open court, rather, arguments on why there should be direct access to this court, and also the ventilating some of the issues that are being brought by the applicants, the President Jacob Zuma, as well as the NPA, and of course the DA also arguing that President Jacob Zuma should have his day in court, and the decision or this conversation between Leonard McCarthy and Bulelani Ngcuka didn't at all taint the prosecution against President Jacob Zuma, because they believe that the allegations are serious allegations. It's allegations that must be tested in a court of law.
Now, Aldrin, let's speak about the current atmosphere in Bloemfontein. Has this matter, or has this case attracted, robust media? Is the media contingency out there in numbers? And let's speak about possible security arrangements for during the 2 days that this case will be heard.
It is a huge matter, and we will be expecting a lot of media houses to be outside the Supreme Court of Appeal tomorrow when the matter is being heard, and probably a few protesters as well. But the difference between this case in 2000 and now in 2017 compared to 2009, when President Jacob Zuma wasn't president of the country, but just the president of the ANC, and contesting to become president of the country, after being elected president of the ANC, is that there's not a lot of a hive of activity as there was back then. If you remember, even outside the Pietermaritzburg High Court, when he made a court appearance, even during the rape case that the president was facing at the time, there were a lot of protests happening outside the courtrooms, people coming out in support of President Jacob Zuma. But this time around, that's not the case. Even if you look when the court case, this particular court case that's being appealed here at the Supreme Court of Appeal, in the North Gauteng High Court, no protests whatsoever from any ANC supporters or supporters of President Jacob Zuma, but rather supporters of the DA, who have been fighting this matter since 2009. And remember quite fondly when Helen Zille was walking out of the North Gauteng High Court with the spy tapes in her hands, in a bag that was sealed and written confidential, and holding it up, and how they were cheering, and there were no ANC supporters inside. And it would seem as though that the support for President Jacob Zuma might have shifted a bit, considering as well the political atmosphere that the country finds itself in at the moment, and how the focus now is on the next president of the ANC and who the next president of the ANC is. And it would almost seem as though that some people believe that President Jacob Zuma doesn't need the support anymore, as the focus has now shifted to the current battle in between the contenders, some 7 or 8 contenders who want to become president of the ANC.
Now, Aldrin, just in wrapping up, can any of the 3 parties take the matter even further if they are unhappy with the decision made by the Supreme Court of Appeals? Can this matter be taken further to the Constitutional Court?
Well, certainly. Any matter that is in front of any court could be taken all the way up to the Constitutional Court, and that's the reason why it's quite clear at this point that this matter would go to the Constitutional Court. Either way the judgment goes, because the DA has said that they are going to go all the way to the Constitutional Court, while we know that the NPA has already applied directly to the Constitutional Court, but they were denied direct access because a lower court, the Supreme Court, was already dealing with this matter in the application by President Jacob Zuma. So quite certainly this matter would go all the way to the Supreme Court, or rather all the way to the Constitutional Court. But considering that there is this appetite for an application for a permanent stay, should the NPA decide to try President Jacob Zuma, this would not be the last time we hear of this matter, even if it goes all the way up to the Constitutional Court. Even after then, we'll probably go into the 80th phase of this case against President Jacob Zuma.
Aldrin, thank you so much for joining us. We'll have to leave it there for now. That was our reporter, Aldrin Sampear, joining us, and he is out in Bloemfontein. Opposition